I want to talk to you a little bit today about firearms prohibition orders. And there's different paths to these type of orders, and I'll give you some examples. So let's say you're charged with a domestic assault or criminal harassment, for example. The police arrest you and you have a firearms acquisition certificate and weapons, in other words, firearms in your home. So the police, for example, are likely to seize those firearms because there's a risk there. That's going to be part of your bail conditions as well. And they're going to hold those pending what happens at the trial. Now, let's say you win your trial. Well, that's great. You've won your trial. The Crown could still decide to go forward with what's called a firearms forfeiture application. And that firearms forfeiture application, it has a lesser burden than a criminal trial. The burden at a criminal trial is to prove a case beyond a reasonable doubt. So you won your domestic assault, you won your criminal harassment because there was a reasonable doubt. But now the Crown thinks, so it's still not desirable in the safety of the public. They bring that application, and there's a lesser test there. It's to a balance of probability. The Crown only has to prove to a balance of probability that it's not desirable in the safety of you or another member of the public for you to have those weapons. It's a tricky hearing. There's evidentiary rules which are different than criminal, including allowing hearsay. And it takes a special touch to be able to win those hearings. It takes an experienced criminal lawyer. Very difficult to represent yourself in one of those hearings, by the way. The other way to lose your weapons is, let's say you lose your trial. Now what the judge is going to do is they can order you, as part of your probation terms, not to possess any weapons, which includes firearms. Weapons can include knives and things like that too. Other, nunchucks, all sorts of things. So you're going to lose that during probation, not have access to it. But the judge is also going to make a weapons order, prohibition order, for a number of years that you're not to have weapons, and forfeit those weapons to the Crown. So those weapons are gone. You can't even have your fire acquisition certificate. That's going to be gone for many years. Depends on the type of crime as to how many years, but it's many years, 5 and 10 years. And, that's going to be a given if you lose. Now, the other path is this. Similar idea. You're charged with a crime, criminal harassment, domestic assault, but they simultaneously bring the firearms forfeiture application right away, right at the outset. Now, with that, they're going to wait for the outcome of your trial. If you win, great, but they could still go forward with that weapons prohibition. Or they're going to say at the end of the trial, you know what, he won the trial going away. I don't think, it doesn't appear to be in anyone's public safety, and we'll let it go. In any case, it requires a lot of solid legal advice from a good lawyer to represent you on this and to hopefully win for you if it's not desirable. I should say if it is desirable for you to have weapons. So it's a tricky area of the law, and our firm is very experienced at doing these type of forfeiture applications and, of course, domestic assault and criminal harassment matters. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.